Judge, that's it.
All right. Did your client wish to say anything?
Judge, I think I'm going to speak for her.
All right. So I want to let the parties know that part of my question, or maybe you can address this, counsel,
Yes, ma'am.
because it says that she is minimizing her role. And it says regarding the instant offense, the defendant stated, I have no comment at this, which I understand.
Sure.
But then she comes back and she does make a comment. And it says the defendant later stated, I feel it needs to be looked into more rather than what they are saying.
We addressed actually this morning, Judge. I think her point on that is she was charged with aggravated robbery. She did not possess, hold, or yield a gun. And so it's been kind of the process of explaining that to her. So I think that she's not minimizing her role as far as doing things with those young men. However, I think she's made a distinction that, contrary to what the state wants to put forward, is that she was not the leader of this. She was a follower in this, and she did not possess or hold a gun. So I think it's to Ms. Ballard's point in the PSI, maybe she could have gotten out of the car and said, hey, don't do that. She didn't do it. But the point of the matter is that she was in the car and not actively terrorizing these people. I make a distinction, but I also understand that if she's there, that she's a part of it.
All right, because I'm reading the PSI. I'm sorry, reading the stipulations, and the stipulation.
Hold on. This is where the legal temperature rises. Boxing the driver in may not sound as dramatic as holding a gun, but under Texas law, participation in a robbery doesn't require pulling the trigger. If you assist, facilitate, or help create the trap, you can be just as legally responsible as the person holding the weapon. So here's the real question for the audience. Is being the driver or the blocker less guilty or just differently involved? Because in criminal law, distinction doesn't always equal exemption.
It says that she was the one who boxed the driver in.
You know, working responsibility for the facts. So I don't think she has said that she's not guilty of this offense. I just think she has a different interpretation of her role versus those young men.
All right. All right. Anything else from the state?
I was informed by our victim advocates that the witness on Zoom was dressed. It was a brown sweater. That's what she's saying that she was wearing.
No, the person who was on Samsung, that wasn't a brown sweater. Unless I'm colorblind or something's going on, they had on no top.
Well, all right, Judge, I just wanted to make sure.
All right. Thank you. All right.
I don't want to overstep, but I do want to make a brief argument next time.
Yes, you may proceed.
So, Judge, when I first started representing this young lady, she was in jail. And as her mother said, usually I have to field those questions, how quickly can we get out of jail? I think Ms. Franklin took a very good approach for a single mom, and that is that I want her to sit with. These are serious charges. I want her to get a taste of incarceration. I want her to understand that you have to be penalized or punished for the things that you do. So 5 months passed by, and so I think that the value in that here in the courtroom today is that she has a taste of incarceration. And I think she's come out of jail, Judge, and from the Roosevelt High School, from Ms. Howard, says she's really doing well in school. It's hard for me to believe she's 17 years old when I met her and charged with such a serious crime. And she's turned 18 and she's only, 3 months into her 18th year. So, Judge, one of those things, she's got a bright future. She's got hopefully acceptance into a school in Atlanta. She's been accepted to UTSA. Those letters, in my opinion, Judge, from Roosevelt High School, those are hard letters to get for the defense. And that's a really fine letter that supports Michaela in her application for probation. I don't want the court to think that she's minimizing this, because we've spent talking about, the what ifs and you can't find yourself in that situation. Her mom was bright enough through some talking that we had to get her sessions with Marcus, and Mr. Harris is very good through the juvenile probation and through the practice of bringing young people in, who specializes in young offenders and working with them with this cognitive behavioral. You can't find yourself in the situation. You can't find yourself around the situation. If you do, then you need to leave. You don't need to be boxing anybody in cars. So I think this has been put square upon Michaela. I think she's done a great job out on bond. I think she's doing a great job in school right now. I can tell you that her relationship with her mother has never been better. I just really beg this court to give this young woman a chance. A conviction, being sent to prison is going to irreparably change her life. Now, I know that there's victims out there who have had their life irreparably changed too. There's nothing we can do about that. But this is a young lady who's clearly on a positive path. And
now we feel the shift. The defense is talking about potential, college acceptances, rehabilitation, second chances. The state is talking about trauma, a mother and a child targeted. This is the collision point in sentencing philosophy. Rehabilitation versus retribution. Do we punish the worst thing someone has ever done, or do we invest in who they might become? For the judge, this isn't emotional, it's structural. It's about precedent. It's about protection of the community. And right now, the scales are trembling.
I'd like for her to stay there with the court's permission.
State.
Judge, the situation here is that they specifically targeted a mother and a young child. That child's been damaged for the rest of his life. He's gone through immense trauma. And the role that Ms. Johnson played here was an important one. She boxed them in. She's the reason why they could not get away. I understand that she's made a lot of progress after the fact, but in that moment, she could have made different choices. Choices is what you're gonna have to make going forward. It's something that the state feels that prison would be appropriate here. The victims feel that prison would be appropriate here. That's what we're asking for.
Judge, I just want to, you see more of these PSIs than I do, but it looks like the juvenile offenders who I think have the more serious role in this. I can't read this correctly, but it looks like one of them had his cases dismissed, maybe placed on probation, and then one was sent to some kind of TYC placement. So I guess if I look at that, Judge, I just argue that there will be some kind of equitable position here by the court to figure out what to do with Michaela. Again, Judge, deferred adjudication on second-degree felony is a good thing. I mean, we all know what deferred adjudication is, but sometimes it doesn't mean a do diddly damn in court. Here, it makes a big difference because it gives her a chance to prove herself, and it gives the court a long leash to make sure that she's doing well. I don't know what else we could bring the court to show that she's remorseful, doing well at home, doing well on her conditions of bond. So again, we would ask that the court wisely place her on deferred adjudication. Understand that she's done 5 hard months in the county jail. I think she spoke about her fear of the jail with Mark Harris in that letter. I think her mom made a good decision, and we're hoping that will sway the court and giving her a chance at a future without being another young Black female with a conviction on her.
Here's the court's problem, and what I think people need to.
That line right there, that's the hammer forming. When a judge says, sometimes it's just a prison offense, that's courtroom code for this. No amount of good grades, therapy sessions, or clean months out on bond erases the severity of the act itself. The presence of a child in the car changes everything, because now it's not just property crime, it's psychological harm. And when nobody paused after hearing, "My son is in the car," that's what the court can't unsee. You can feel it. The tone has hardened.
To look at. Sometimes punishment, and all attorneys will tell you when we're in law school, they tell you about the purposes of sentencing. Sometimes the purpose of sentence is for rehabilitation. Sometimes it's just punishment. Sometimes it's protecting the community. There are a whole host. But your problem is sometimes when you've done something that is considered so horrendous, right? No matter the changes you've made, sometimes it's just a prison offense. There are a lot of people who do things that I'm sure if they could go back in time, they would have changed it. They would have said, I wouldn't have done it. But the boxing of someone in with your vehicle, and I read the PSI report and I read the stipulations. In the stipulations, the driver of the vehicle said, hey, my son is in the car. And that didn't give anybody pause. I would think that there are certain things that should give people pause. For example, if somebody holds somebody at gunpoint and they want to steal their vehicle, they would say, oh my gosh, shucks, I didn't know there was a child in this car. Let me pause. But they gave nobody pause. Everybody just still continued with what they were going to do. That's a problem for the court.
6 years, not deferred adjudication, not probation, prison. Notice something important. The judge says she's following the plea bargain agreement. That means this outcome was negotiated ahead of time. This wasn't a surprise bombshell, but it still lands heavy. 6 years at 18 years old, a felony conviction, loss of firearm rights, limited appeal options. This is the moment where courtroom theory becomes real-life consequence. And now the camera shifts because the system keeps moving. Another defendant, another story. But for Michaela, life just split into before and after.
So this is what the
Judge,
court,
isn't that she was, no matter what her role was, it was still going to be something that was horrendous because it's a robbery.
Yeah.
So I'm not trying to argue with the court, but under that circumstance, then no one should be eligible for deferred adjudication.
well, counsel, where there are different types of robbery. And there are some robberies that don't involve a child. State?
Your Honor, so right here, one thing I did notice in the letter for the psychiatrist, something that is bothering me, I've seen it somewhere in here, is that Ms. Johnson, she said she gave them a ride but did not know their intentions, but she played a role in boxing the men. She says that she had never had or handled a gun that night. When the police lit up her car, the boys threatened her if she didn't keep going. One of the boys threatened to shoot her if she stopped. Nowhere is that brought up in the report that she had mentioned that she had said that they had threatened her. So that's just something that is.
Well, I don't think it's feeling, so it's not going to be in a police report.
Right,
but I can tell you that was her feeling on this. She did feel threatened by these two young juvenile offenders. We're here today to take responsibility and not make excuses. So that's all for that, Judge.
All right. This is anything else before the court makes its ruling?
Your Honor.
All right. This is what the court is going to do. Court is going to find you guilty, taking consideration 2023 CR 3850, 2023 CR 3849, grand jury number 806632. There's to be restitution of $110 to John Bright in grand jury number 806632. Give you credit for any time served. I'm going to retain jurisdiction. Your attorney will tell you what that means, and I'm going to send you to 6 years in the prison. Did you review what it's entitled trial court certification with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Okay. And Mr. Hancock, you can explain to her what that means.
I will, Judge.
All right. All right. After this case, it will be Mr. Serta. All right. Court is calling 2018 CR 0858, State of Texas versus Christopher Lemire. Can I have the parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense.
For the defendant.
And are you Christopher Lemire?
Yes, sir.
All right. I'm going to show you what's entitled Motion to Enter Adjudication of Guilty and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Christopher Scott Lemire who was placed on deferred adjudication in 2018 CR 0858 for the offense of burglary of a habitation on May 13, 2019 for a term of 6 years? Is that you? State?
Your Honor, do you have the supplemental motion?
Let me see. Yes. And I'm also showing you the state's motion to supplement motion to enter adjudication of guilt and revoke community supervision. Did you review that document with your attorney as well? Did you understand it?
Yes, Your Honor.
All right, and counsel, the court was just tendered the supplement. Are you prepared to proceed?
We are prepared, Your Honor.
All right, state.
Violated condition number 33 on or about the 17th day of November 2023 in Bexar County, Texas. The defendant, Christopher Scott Lemire, did then and there fail to comply with the rules, regulations, or instructions of the res care facility, in that the defendant threatened other residents and destroyed property in violation of condition number 33.
How do you plead to that? True or not true?
Your Honor, we waive the other violations alleged in the motion to enter.
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 33, the court could find it true, grant the motion, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition 33?
Yes, Your Honor.
Court will find violation of condition number 33 true. Is there a proposed agreement?
There is, Your Honor. We're asking that you deny the motion, continue the defendant on deferred adjudication, and we're asking that he attend the state ISF cognitive track program, Your Honor.
All right, is this going to even work? Because respite care was intensive and that didn't work.
I think the difference, Judge, from what I remember from the last hearing in September, when we had these questions for res care, are y'all going to make sure he does the GPS? Are y'all going to make sure he thinks various things? And my from that hearing is they're like, we'll do our best. That's not really up to us. I think state ISF is more structured. My understanding is that they are going to make sure he's complying with the rest of his probation, Judge.
And Judge, we've actually had issues with rest care. They've actually given him the wrong medication at times. In fact, this incident was a result of him being wrongly medicated. So his mother is also looking, once he gets out of IFSET, to get some other placements for him. And she's in the process of getting that done. I think he's got another year basically of probation left once he gets out.
Probation?
Yes.
Could y'all please whisper? Yes.
At this point, I think the recommendation would be for either state ISF or DDRF. He is not able to go back to the rest care facility.
And I know there have been issues with rest care because I don't know if he cognitively is able to be there, because I understand them saying we can't make sure that his GPS is charged. That's something he should do. And I understand because of mental issues, he can't charge it. So does anybody think he's going to be successful? That's my question.
I think I'd like to give him the shot, Judge. I understand
He's not going to survive in prison, Judge.
Well, sometimes prison is prison. It's not a happy place. But at some point, there is nothing else I can do. Somebody write your legislator, write your congressman and tell them we need placements for people who maybe are low functioning, people who have mental health issues, because otherwise all I'm doing is rubber stamping saying, oh, let's try this. I'm going to try it. But Mr. Lemire, this is the last stop. There's nothing else for me to try with you. I don't think state ISF is going to work because respite care is more intensive than state ISF. But this is what everybody is telling me they think will work. I hope it will work.
I'm gonna walk a straight line, Your Honor.
Well, Mr. Lemire, I understand you're telling me that, but that's what you told me last time.
So last time they said that they doubted that I would be able to do the AA sober support, and I've been doing better at that and sending it every day. They doubted that I would be able to do that, and I did it.
All right. I understand the issues and the limitations that we have here in Bexar County and elsewhere. I'm going to deny the motion, extend you for 1 year, alternate amend conditions. We can do a referral to DDRF and also state ISF.
Your Honor, I need one.
Which one do you think is best probation, DDRF or state ISF? All right.
I think it's better.
All right. So we're going to alternate amend conditions to include DDRF. And hopefully they can address the issues that you have. You understand?
Sure.
All right. Do you have any questions about anything?
Does that mean I would be getting off probation in May of 2026?
Whatever the extension is for the year, That will be 2026.
So I had contacted my probation officer and I called her and twice, 2 or 3 times and she didn't answer, and I had left her voicemail like 2 weeks before the incident occurred, trying to tell her I was having a medication issue, and she never called me back or answered her phone. I wondered if maybe I could get a different probation officer.
All right, so let's do this first. I'm going to make a notation of that in your file, and I have made a notation of that. We're going to see about placing you at DDRF, and hopefully they will make sure that you have the right medications, because I'm not a medical doctor. I can't put you on specific medications. And if there's an issue with DDRF, just let us know, okay? All right, thank you.
Good luck.